I just give you an anecdote. One of a toppers of one of a very prestigious law colleges joined our office as one of my juniors to assist me. His CV was very impressive, but when he joined the courts, the very first day he came running to me because he was sent to know the charges upon the accused against which we were about to apply the bail. So he was sent there to interview the accused to know about the charges. He came running and he said, "Sir, he's telling me 379. And what is that?" Because he went with a mind that the accused will tell him about the incident. And he will tell him that the police has wrongly charged him about that incident. But the accused gave him a section. So he was zapped. The stopper was zapped. What is 379? Do you know what is 379? And to add up to that, when I asked him, "Are you're not aware of 379? He said, "I am aware of 379, multiple 379s. Which statutes 379? Because section 379 may be into the Companies Act also. 379 may be into the IPC also, 379 into CRPC also. So which statutes 379? This accused has suddenly given me 379. Now 379 is theft into IPC. And when I told him that when you are going to an accused where we are to apply bail, naturally you have to see criminal law. And the substantive criminal law is given into IPC. So 379 of the IPC you have to see. And you have to know what is 379. Because being a topper, you are theoretically so perfect, but that thief is ahead of you because he's practically operating into that. So he's charged multiple times about this incident, that. But see, the person who is committing a crime does not know law. He doesn't commit a crime कि आज मैं 4-5 सेक्शन तो वायलेट करके आता हूँ. ऐसे तो जाता नहीं वो तो जाता है, अपना काम करता है. बाद में लॉ एनफोर्सिंग अथॉरिटीज उसके पूरे एक्शन को डिसाइफर कर करके पता लगाती हैं कि भाई कौन कौन सा लॉ वायलेट कर दिया. Isn't it? Police puts charges, sections on the entire incident, dividing कौन कौन सा लॉ वायलेट किया. थेफ्ट अकेला है कि थेफ्ट के साथ ट्रेसपास भी है. थेफ्ट के साथ ट्रेसपास भी है कि क्रिमिनल फोर्स भी है. ये सब तो डिसाइफर करने का काम लॉ एनफोर्सिंग अथॉरिटी का है, और उसको फर्दर डिसाइफर करने का काम लॉयर्स का है, जो कोर्ट में कहते हैं कि नहीं साहब ये वाला चार्ज तो बनता ही नहीं. जब चोरी के लिए ये अक्यूज्ड गया था तो दरवाजा तो खुला हुआ था, उसको पता ही नहीं चला कि ये तो किसी का घर है, वो तो समझा ये तो रास्ता है. तो ट्रेसपास कैसे बन गया? चोरी का डिफेंस आप करते हैं, इंग्रेडिएंट्स 379 के ढूंढ के निकालते हैं कि साहब देखिए, वेयर वॉज द मोटिव, वेयर वॉज द इंटेंशन, वेयर वॉज द मैलिस. ये तो वहां पड़ा हुआ था, इसको पता ही नहीं चला that this belongs to the owner of this house. He thought it's lying. He rather took care कि मैं ले जाता हूं या वरना ये चीज बर्बाद ना हो जाए. These kind of defenses you cultivate, isn't it? It's a different story that whether the judge is convinced or not. But remember, what is very important is that never sit on the laurels. Keep reading, keep finding, keep innovating. Otherwise, you'd be lagging behind. And a very, very important saying in the field of law is that law is a very jealous mistress. बहुत जल्दी रूठ जाती है. आपने अगर ध्यान नहीं दिया तो ये लॉ रूपी प्रेमिका बहुत जल्दी रूठ जाती है. आप कहीं और ध्यान दे रहे हैं, चलो मैं तो चली, फिर आप पीछे पीछे ढूंढते रहिए. एवरीडे लॉ चेंज हो जाता है. आपने ध्यान नहीं दिया, कल कुछ और हो जाएगा. And you look like a fool before the judge when you're arguing something which has already been upturned by the Supreme Court. Maybe the last day, or maybe the last week, or maybe the last month. If you're not updating yourself, things may change. Isn't it? Therefore, Motor Vehicles Act, under Section 140, when introduced this rule of absolute liability, by the year 1994, the need was felt to evolve further. So therefore, Section 163A was introduced under Motor Vehicles Act. Now 163A went beyond the boundaries of 50,000 and 25,000. But the Parliament in its wisdom felt that to put up a claim and the courts to decide whether the claim is genuine or false, the court normally has to undergo the whole process of a trial to find out the truth or the falsehood. To cut it short, that whether the amount of the claim is justified or not, the Parliament created benchmarks of the whole calculation of the claim. And those benchmarks are put at the end of the Motor Vehicles Act under Schedule 2. So when you read Section 163A, always read it along with Schedule 2. If you have a book of Motor Vehicles Act, go to 163A, make a plus sign, write Schedule 2. So that whenever you read 163A, automatically you jump to Schedule 2 also. So what has been done under Schedule 2? Schedule 2 has enhanced that scope of rule of absolute liability of 140. That this 50,000 is instant or 25,000 is instant. But what is the adequate compensation to the victim has to take care certain other factors also, like the age of the victim, and what is the years of life left, that had he not been victimized with this accident, had he been living a very normal, healthy life, the balance of the life would have entitled him to earn this much. During a healthy living, he would have earned this much. So the age is a very important factor to determine the damages or the compensation. The second factor which is to be taken into consideration is the income of that victim. What was his average income at the time of accident? Because loss of earnings can be calculated on the basis of your earnings only. if you have been earning, suppose if you are a daily wage earner and your earning on daily basis is rupees 500 per day. Now that you are disabled permanently, you have lost that 500 rupees earning per day. What if you are a managing director of a company and your salary was in 6 figures per month? Now due to this accident, you are unable to attend those duties, so you've lost the earning of 6 figures per month. So over and above the age, the second factor which is taken into consideration is the income of the victim. So that adequate compensation must be given to the victim on the basis of these factors. Another factor which is taken into consideration is the number of dependents. Because when your income is lost, the life of your dependents also get affected. When you were regularly income, their life was very healthy, peaceful, good. Now in the absence and the loss of this income, their life will also be crippled. So that is also a factor taken into consideration. And all these factors, with the life expectancy, is taken into consideration into Schedule 2. And already the law has taken care of the entire calculation. So therefore the courts have only to do is to go by the facts of the victim, that what is your age, what was your average income, what are the number of dependents you have, put it to the multiplier of that schedule, and you come with the ready-made amount of the compensation. This is done to curtail the long drawn trial, the period by the time the courts come to a conclusion that this is an adequate compensation. The agony has multiplied, because with the lack of money, each day is costing. So to curtail all that agony, the pain, the whole multiplier is given under under Schedule 2, read with Section 163A. So this is again a slight further extension of rule of absolute liability. 163A also goes with the premise of no fault, that a minimum this much which is given under Schedule 2 has to be paid. This is called the evolution of law. Because when you come to know that the operation of law is not sufficient, the provisions of the statutes are not adequately compensating the victim, you have to come up with a further innovative idea. And that is why what I suggest to you all, another Guru Mantra, that don't limit yourself to simply reproducing whatever the law you read in your syllabus. Because the whole exam pattern of India is based on reproduction. You read your syllabus, your textbooks, and you simply reproduce it on the answer sheets. So it's basically whatever you eat, you vomit. Nothing beyond it. But the factor to be taken into consideration in the actual field of law is much beyond that. There are several anecdotes that how lawyers cultivated a new defense. Several anecdotes you'll find.